Good evening and welcome to Transition Talks Tuesdays. My name's Tim Markle. I'm director of the Southern Regional Center for Children and Youth with Special Healthcare Needs. This version of Transition Talks Tuesdays is in partnership with Juneau County and Adams County, my favorite northernmost counties of the Southern region. Whenever I get to visit them, I get to say I'm going up north, which everybody else is just like, you're not going up north. But I insist that they are my northernmost counties. And so therefore, when I get to visit them, I get to go up north. So tonight, and this is also especially in partnership with New Lisbon High School, who has been a stalwart in transition stuff for many years now. So I appreciate that. Tonight, we have Tammy Jackson from the Wisconsin Board for People with Developmental Disabilities. And we are excited to have her here to share about supported decision making. Tammy, again, thank you for being here. This has just been awesome to continue to hear about supported decision making. I really appreciate it.
Hey, I love talking about it, and I'm here for you guys. So tonight we have a smaller group so we can be a little more intimate. I can't actually see the chat when I'm presenting, so it's okay to interrupt me, and I will tell you if I'm getting to your question later, or we'll just take care of it right then and there. That's fine. You'll see on this first screen, there's a whole big list of logos. These are all organizations that were part of passing the supported decision-making agreement law in 2018, and I was one of the people leading that effort. So tonight we're going to talk about several things. Every time I do this presentation, we spend a lot of time talking about guardianship, powers of attorney, and other things that aren't supported decision-making, because it's really important people have knowledge about all of the different options that they now have. And then we will spend part of our time talking about, what is actually supported decision-making under the law, and how would you use this in your life? I see we have a couple of folks that I'm assuming are professionals, probably teachers. I see high school after your name, and I assume probably a few parents. Is that about right? Is that who we have in the audience today? Hearing no dissent.
There is no dissent. I was looking at the list, and we have one service provider, we got some educators, and we have a family member or two. So okay. Yes, you are right on target.
I always ask because sometimes we get a variety of people who have different professional roles or family members that are thinking about different things. And last week I presented in front of primarily families with people in their lives who have mental health issues, which is a really different flavor of how to use this particular law. So without that, no further ado, we are going to get started. I always start out by saying what Wisconsin law presumes. If you are over 18 in this state, which I am, and Tim is, and everybody else here is, Wisconsin presumes that you are legally competent to make your own decisions. Now, if they knew Tim and I better, they might have a different opinion, but they don't. And so the law just says, okay, we're going to put an arbitrary age, and we're going to assume that if you have achieved that age, you're competent. Our brains aren't fully developed until 25. So I don't know if you remember decisions you made between 18 and 25 that you might make differently now. I have a few. 18 is what the magic number is in the statute.
If you wanted to go ahead and put in the chat those decisions that you regretted making, no, don't do that. Don't do that. That'd be horribly fun, but please don't do that.
And I always say that because what Wisconsin law presumes about everyone over 18 and what society presumes people with disabilities can do are often very different. It's important to remember decision-making is learned. We get practice throughout our lives about all sorts of decision making, and we get better at it. We also get better at it because with and anything that you need practice, you need the opportunity to make decisions, right? You need experience And we all use some combination of support when we have a decision we haven't run into before. This is normal stuff. Your children and your students have been practicing decision making. I know it sometimes doesn't seem that way, but really, I have a 5-year-old and a 3-year-old, so I have lots of questions about how this all will work out in the end. But you have been helping prepare them in a variety of ways to make their own decisions throughout their lives without even knowing it. So every time you ask for a simple choice, do you want X for breakfast or Y for breakfast? You're allowing them to assess preferences. You're allowing them to have some control over their lives. As they get older, you're letting them figure out who they are and how they want to spend their time. And all the way through, you probably are giving them practice with increasing responsibility. And when you think about the very beginning, when you had this infant in your arms and who they are now, there's quite a big difference. And there will continue to be growth throughout their lives. Now, remember what I just said. Wisconsin law assumes that everybody over 18 is competent to make their own decisions. Our culture often assumes the exact opposite for people with disabilities. There is actually the term for this bias is called ableism, where there's an assumption that because there is a disability present, that automatically means that that person is not able to or shouldn't be in control of their lives. And parents, you can correct me if I'm wrong, but some of these ableism may look pretty familiar to you. If you have been a family member and in a meeting and a professional sits down and starts talking to you about the person with a disability in front of them about decisions without involving them, that is a form of ableism, right? There's an assumption that the person with a disability is not part of the conversation about their decisions related to them. For sometimes professionals, and I always pick on the medical folks because they're usually not at the presentation, so I feel like it's fair game. But a lot of medical professionals, if they walk in and they see somebody who is older or has a physical disability or a visible developmental disability, or they talk to somebody and it isn't somebody who's expressing themselves in, typical communication, they may assume that somebody has a guardian. Oh, you aren't the person I talk to. This kind of stuff happens all the time, all the way through, and it's a cultural bias. Why is that important? It's important to remember that as much as people are learning about decision making through all of their experiences, they're also learning from these experiences that you are familiar with every day. And what they're learning is profoundly negative when you are exposed to ableism. What they're learning is I don't have a voice even when the conversation's about me. Somebody else decides for me. Maybe they're learning that what they want, they don't feel like they can tell you. And maybe their preferences don't matter, right? I don't have control. I can't say no. I have to be compliant. There are consequences when I'm not compliant that are more negative than asserting myself. And this is all really important because those are all things that are very good predictors of abuse and neglect, right? It should come as no surprise to any of us that when you feel like you have some control over your own life and some ability to set your own goals and directions and ability to say no, that you feel better about yourself and that you feel like you have more autonomy. And there are studies that in fact prove that people who self-determination is the longer kind of jargony way to say, I make decisions about me for me. People who make their own decisions are healthier, they're more independent, more well-adjusted, And they're safer because they can recognize, they have probably enough experience to recognize when something doesn't feel right and to say something about it when it doesn't feel right. This slide, every year across the nation, the National Core Indicators collects data. Specifically, it's a big survey that they do with people with intellectual and developmental disabilities, primarily those who are in our long-term care programs like family care and others. And the reason I put this in here is to kind of show, is to show you that, this only measures whether these things are present or not present in somebody's life. And I want you to know that present, not present doesn't mean that they were two good choices, right? It just means that they were there. So I'll throw that caveat out. But I want you to look at how many people are responding on what you and I might consider as being pretty basic things that we would expect for ourselves. We have almost 60% saying, I don't get to choose where I work. I don't get to choose who I live with. I don't really get to live with people who, with and without disabilities. No, I don't get to exercise my rights. I don't get to do personal goals. It's pretty high. And it shouldn't be a surprise that if those things are not present for you, you probably are, not feeling real great about it. So parents, this slide is really about you for the professionals. But if this sounds familiar, reaffirm me, okay? Transition, we talk about transition like it's a thing, but it's a many-pronged Hydra monster where everything is going on all at the same time. And lots of the people that you interact with have one small piece of the total picture that you're having to deal with. And they forget that you are dealing with other things too. So I always like to talk about why this period is so stressful. Parents are being asked to make all sorts of consequential, sometimes life-altering decisions all at the same time. And none of these systems are easy to navigate. All of them require everything being exactly right paperwork wise, or you get to start over, or you get to have 5 phone calls where you should have had 1. All of those things. Social Security, you're trying to figure out which long-term care program you might be in. What transition are you doing to medical doctors once you become an adult? That arbitrary line again, you're getting new medical staff. Are you doing DVR? Are you needing to all these things? And the thing is, that'd be bad enough, but they also got to do all the other stuff that they normally have to do anyway. And a lot of families have extraordinarily stressful lives anyway. Many of them are working part or full time. Some of them are working only enough because they're also picking up a lot of caregiving duties that they are doing. Nights, weekends, evenings aren't necessarily free, neither are weekends. There's a lack of paid help. They have other children, they have older parents, they have all the things in all of our lives that are all going on at the same time that are always stressful. And so now we add on this thing of, well, 18 is coming. Have you done guardianship yet? And for a lot of families, that is how the question is asked. Have you gotten guardianship yet? And many families just described to me saying, well, I'm doing all of this other administrative stuff, and that sounded just like something to be added to the pile of things to do. And they really don't have any understanding of what it is they're signing up for. It just gets suggested, puts in their pile, and they complete the paperwork, because parents with people with disabilities, they get trained really early on how to complete paperwork. That is a skill set that the parents develop very early. I spent a lot of time on this slide. This slide is intended to show you all of the different options that you have or that people have if you need help with decisions. And there's an arrow on the bottom of the slide. And you'll see on the slide next to the green column, there's less limiting. And on the other side of the arrow is more limiting. What we're talking about when I say limiting is your civil rights to make your own decision. Remember, Wisconsin presumes that you are, if you're 18, you're legally competent to make your own decisions, unless a court decides you're not, right? So on the side of the form here that says release forms, the green side, there is absolutely nobody's taking away your civil rights when you sign a release form. But on the purple side of things, limited or full guardianship, yeah, a judge is saying, legally, we don't think you're competent, and therefore you are losing your rights in some pretty big categories to make your own decisions, and we are transferring your rights to make your own decisions to somebody else. That is the guardian. We'll talk about why that's consequential, but I'm pointing that out to say that many families with people with developmental disabilities, they start at the purple column, and you can't go any more, you can't get any more severe than that. So they're starting at the end point. And yet there are all of these other options that can be used in combination with each other that might mean that you don't need to do guardianship at all. And a lot of folks don't know about it when they hear the question, have you gotten guardianship yet? So release forms, we're used to this. We're very talented at signing forms. All of us have probably done this at a bank or at a hospital or some other place of business. They have you sign a release form to acknowledge that you are giving permission to somebody else to see your information, even if that person is somebody internal to the company, maybe. Release forms can be in effect in perpetuity if you want, or you might have to sign them every time you're asking for different information. No, this has nothing to do with your civil rights. You're just acknowledging and giving permission. But it's a really valuable tool for a lot of families with disabilities, because it means that, the person with a disability can say, hey, I want my Aunt Maud to be able to see this information. And the professionals should say, okay, well, we need you to sign a release form so that you give us permission to do that. Okay, sign it. Aunt Maud sees the information. Nobody had to go to court and lose their civil rights to do that. In the yellow column, supported decision-making agreements. And I have in parentheses Wisconsin, because there's about, I think, 18 states that have supported decision-making laws and counting. We were the fourth state to pass it. And like powers of attorney and guardianship laws in other states, every state's supported decision-making law is also a little bit different. They all have some things in common. The basic thing that they have in common is the acknowledgement that you can ask for help to make, in figuring out your decision without somebody else making it for you. So supported decision making, the person makes all of their own decisions, but they identify a supporter to help to fulfill certain roles for them. So you have a supported decision-making agreement, and it's the person saying, here's what I want help with. Here's the person I want to do certain things for me. And here are the things that I want them to do. And I'm going to make the decision at the end, but I need this person to help me gather information, help me understand the information, help me compare options, or help me communicate my decision to others. That's what I really need. I don't need them making a decision for me. I'm perfectly fine making my own decision, but I want somebody to, walk with me as I think through what I want to do. In the blue column, for those of you who are familiar with Social Security, there is something called a representative payee. Now we're getting kind of to the middle of the continuum. Representative payee is somebody who is authorized to receive the Social Security payments. And they can't just spend all the money on whatever they want. Representative payees are responsible for making sure like they receive the benefit check and they pay out the rent and all of the other bills. But they also are the person who receives all of that money. So they do have control over that benefit check. So you are losing, if you're the person, the beneficiary, you are losing complete control over all the funding that's coming in. And there are some representative payees that perhaps may decide that, nope, I'm not giving you the balance of your benefit check. Nope, I'm not going to allow you to spend money on that. And others who see it as a far more flexible relationship. And I just mentioned that because, when somebody else has control over something as useful as finances, that does mean that they have some amount of control over the person in terms of how that money is spent and whether or not that person has access. So it can be, there's a real usefulness for it, but it can also be abused. All right, in the red column, we have powers of attorney. And these are really used for two major decision areas in this state: powers of attorney for medical and powers of attorney over finances. So two pretty big categories of decision making. And powers of attorney can be written in a lot of different ways. So the basic premise of a power of attorney is that you have another person, the power of attorney, who under some circumstances, or potentially always, depending on how you write your power of attorney, has decision-making authority co-equal or on behalf of the person on either medical or financial pieces. So it's important to remember that the power of attorney for finances and the power of attorney for medical don't need to be the same person, and that these documents are very flexible. So I usually use a medical example because it's more familiar for folks. So let's say Tim is my power of attorney for medical stuff. And I have it set up that Tim doesn't always make my medical decisions for me. He's not a durable power of attorney. But if I get hit by a bus and I'm in a coma, and it's very clearly I am not conscious and I am not capable of making medical decisions, that power of attorney is triggered. And all of a sudden, Tim comes in and he is making those decisions for me while I am incapacitated. I wake up, Tim is no longer the power of attorney. I get to make my own decisions again. So it's very specific to, it's been triggered because of circumstance and is in effect until the circumstance is over. A durable power of attorney is a little bit different. And in that case, Tim might be always co-equally making decisions. Those are a little more common in my experience with financial powers of attorney. Really trust your financial durable power of attorney, because it means that the durable power of attorney can always make decisions whenever. It's not triggered. It's just always in effect. Okay. You can use powers of attorney in combination with supported decision-making agreements. You can use a representative payee in combination with those things. There's nothing saying you can't use all of these tools to design a support plan that is appropriate for your person. Then we get to the purple column, which we'll spend a little time with. Limited or full guardianship is really a matter of degree. Now we're at a place where you are petitioning the court, going before the judge after having a medical evaluation, and the judge's job is to determine whether or not the person who might be under guardianship is legally capable of making their own decisions. And if the answer is no, you, the person, lose your civil rights, and those civil rights, somebody else makes your decisions for you. That's very simplistic, but it's accurate. There is a guardian of the person and a guardian of the estate. Those don't need to be the same person. You can be a guardian of the estate, and the person can retain their rights that are covered under guardian of person. Limited guardianship just means you lose fewer rights. Full guardianship means you lose them all. So there's different aspects of guardianship, but the basic thing that all of those things do is you are losing your civil rights pretty much permanently to make your own decisions. And it's the most restrictive thing that can happen to anybody. Some of you may have been following the Britney Spears and other cases in the media. That is a person who was under guardianship. When I do this presentation, all of these things are crowdsourced just from folks who have attended this presentation over the years. So maybe you have even heard some of these things said to you. You are not alone. These are very common things that kind of get repeated, and none of them are true. Sometimes families will say, well, I was told that if I wanted to attend an IEP meeting, I had to be the guardian. That is absolutely false. Absolutely false. Nothing under IDEA or any other place requires a guardian to be at the meeting. What they're really saying is if the student has turned 18, they are the ones in charge of the meeting and they need to give permission for you to attend. Well, Dean asks the student, hey, do you want me to come to your meeting? And they'll probably say yes, because you've always been there before. You don't need to take their rights away to attend a meeting. There's an idea that guardianship, for various reasons, is somehow protective. Guardianship is a piece of paper. It's not a get out of jail free card or a way that if you do something that's against the law and you're under guardianship, you aren't held accountable. That's not the case. It doesn't protect people from all of the fears that keep all of us up at night about assault or other types of abuse. It's just a piece of paper. People think that guardianships can be changed. They really are almost never changed. And there are a couple of reasons for that. First of all, you have to keep going back to the court to modify it. Once a guardianship is in place, the court's always in charge. It's not the family that's in charge. The court may consider what you have to say about it, but the judge is the one making the ruling. That's the person who is in power in the court. They are making their decisions. And they, once been adjudicated as incompetent, going back later to it means that the judge has to say, well, you weren't competent then. What makes you competent now? What's changed? You as the person under guardianship have to almost prove in a negative way that you somehow you have magically become more competent than you were before. And that's a really high burden of proof, to be honest. And for all those folks who probably guardianship was imposed when it wasn't strictly necessary, well, now you've got a really hard job. And the courts will pick who is the next guardian. You can identify a successor. We'll talk about some of that later. But nobody gets to predict the future. So even the person that you identify as the successor guardian, well, when it's time for them to succeed, maybe they aren't around, right? For whatever reason. Families aren't the only people that have some ideas about guardianship that aren't true. A lot of professionals have a lot of misconceptions as well. Guardians don't have full power over their person. But again, going back to the cultural bias against people with disabilities, that ableism, where we assume the presence of a disability means a lower capacity, or that those people shouldn't be making their own decisions. There is a tendency for folks to want to look to whomever else for all decisions. And a lot of times professionals might believe that anybody with a disability has a guardian. Not true. They don't necessarily understand what a guardian is or isn't supposed to do, or even if they can confirm who they are. If I walked into an office with Tim, and especially if Tim had a visible disability or did not communicate in a traditional manner, and I walked in and I said, I'm Tammy, I'm Tim's guardian, almost no one would question me. And they wouldn't ask to see my ID, and they wouldn't ask to see my letter of guardianship to prove who I was. That's scary, because I said I was his guardian, and essentially they're talking to me about any decision I want to make about him. Whew. Most of us wouldn't like that. For families, again, a lot of times people aren't kind of thinking about the full lifespan, not only of their person, but of themselves. And this is hard to talk about because you're making a decision with a young person, and it's hard to think about your own mortality as part of that person's lifespan. Lots of families, they're making a decision at a point in time, and it's hard to think about, well, what does that look like 5 years from now, 10 years from now, 20, 30 years from now? All the time, I have parents who are in their 70s and 80s who are going, what do you mean there's going to be another guardian after me? There's no one left. There'll be another guardian. And it might be a corporate guardian who doesn't know your person and has 50 other cases. Once you're under guardianship, there will be another guardian. A lot of times, folks who are filling out that paperwork, oh, we're so good at checking boxes and filling out forms. They'll check, the guardian form is really easy. It has little boxes and you check them all off. People don't realize they're checking off full sections of civil rights to take away. Sometimes they figured out after the fact that they've taken away their person's right to hunt and to fish, and to vote, and to marry, and other big things that maybe they did or didn't intend. Sometimes courts too, you can petition for a limited guardianship where you're not taking everybody's rights away, but again, that judge is in charge. And that judge may say, nope, we're going to do full guardianship, even if that's not what you want, because you're not in charge, the judge. A lot of times people don't realize limited guardianship is an option. I always pause here because, we've been talking about professionals and we've been talking about families. The one person that we haven't been talking about is the person who will end up under guardianship. And that is very typically true. The conversation we have about what to do about somebody else's, about the person's decision-making is rarely includes the actual person who will be subject to guardianship. That's really important because they're not consulted. Sometimes they don't even know what is happening. I have a young man with cerebral palsy who works full-time at a job, and he was 24 hours away from being put under guardianship and did not know it. He knew he had a court appointment the next day, and he didn't know what it was about. And his parents had just set this up because they were told to do so. He attended the only reason that man is not under guardianship is he attended a session at a conference and went unsupported decision making and went, hey, this sounds like something that could be useful to me. And then the family finally deconstructed what was happening. So, if for most of us, if you were to ask me, do you sometimes need a little support and help making some decisions? Most of us would all say yes, right? Sometime. And then we would probably even say yes to, would you like me to help you on occasion when you have something that you really need another perspective on? Most of us would say yes. Most of us would never say yes if the question was phrased, hey, you're 18. Would you like me to make all of your decisions for you for the rest of your life? I think most people would say no. And people with disabilities are most people. There is also, we talked about all of the things that people learn when they do not have the ability to make their own decisions. People who are under guardianship, that gets reinforced. And it leads to what they describe as an erosion or a creep of their rights. So guardians aren't, they aren't mean people. They're sometimes well-meaning. But because there's not a solid understanding of what the role of guardian is, they tend to start making more and more decisions. And our guardianship law is actually pretty good, but nobody reads the statutes recreationally, except for me. So, in practice, what happens is that guardians may not be aware that they are making decisions they don't have the authority to make, or shouldn't be making, or aren't necessarily in the spirit of our law. And guardians can make major decisions. That's the other thing folks really don't understand. You're the guardian, the buck stops with you. It's not like there's a whole network of people and supportive decision-making agreements that all take a part of that role. A guardian, you're the person, you're the decider. And that can mean major decisions, like where somebody lives, whether or not they get medical treatment, rare cases, whether or not they die. I mean, I'm not trying to be dramatic, but we can't overstate that the guardian is really the person who is entrusted with all of those decisions. And it's a lot. You get administrative requirements too with that. So basically, where a lot of people start, families with IDD, is the most restrictive option. And that probably shouldn't be the first option. Even if guardianship is granted, I always put this in because as a guardian, you should be acting and making decisions that put the least amount of restriction and have the person most highly integrated. And you're making efforts to identify and honor preferences that the individual has. In practice, a lot of times that doesn't happen for people. Okay, so supported decision-making. What is it based on? Supported decision-making is something that you and all of your friends and everyone you know has experience with. What is it really? You have the right to make your own choices, and you get help sometimes when you're making choices. When you're crowdsourcing about what kind of car to buy, or whether, who should do your taxes, or, how do I do an apartment search? You probably ask some network of people who you know for advice, or you ask somebody who you perceive has some expertise in the narrow thing that you want to, hey, is Joe a good mechanic? That kind of thing. We do it all the time. We all use supported decision-making. Supported decision-making agreements are a way to formalize that for certain folks in the state. Under the law, lots of people can use supported decision-making agreements. People with intellectual and developmental disabilities, with mental health conditions, people with physical disabilities, or any combination of degenerative diseases or conditions that interfere with the ability to provide self-care or limit life activities. Pretty broad categories. They're meant to encompass as many people as possible. You'll notice that we don't have an age in here. That's because life happens all the time. And, a person who's age 50 who has multiple sclerosis, who needs a supporter to go in with them and help them communicate to providers, shouldn't be excluded from having this tool because they're not 60. So we were very deliberate to make sure that older adults can certainly use these agreements, but you can use them at any age. The other big flexibility here is, unlike powers of attorney, which focus on primarily healthcare and financial decisions, supported decision-making can really be used for any area of decision-making. So if you have any decision you need to make that you want help with, you could tailor your agreement to do it. The person is always the decider. Supporters don't get any rights over that person. Supporters don't make the person's decisions. They can't sign legal documents. They can't, can't spend their money without them knowing, all of those things. They only have the authority and the role granted to them by the person. the person is always the decider, and they're always able to adjust their supported decision making. So what does a supporter do? The law says you can have the supporter do 4 things, or some of these things. You could have, like, there are some people who might only want help accessing information. That's okay. There are people who might want, help understanding that information and understanding options. These are all roles that the person specifies what they want their supporter to do. The last one, I actually underestimated vastly when we passed this law. There are a lot of people, the only thing they want is for somebody that knows them well to help make sure they are accurately understood by professionals who don't know them. And for folks who are deaf, for folks who have speech impediments or are nonverbal, this is the thing that they want. They're perfectly capable of making their own decisions, but they need somebody to translate to the professional, and maybe they need some translation from the professional back to them. The law says that if you need to sign a release form, you need to sign a release form. So you don't get to, just ask for whatever information about the person you want. It has to be related to the decision you're making. You may have to sign that, a release form to get it. That's fine. And that, you're supposed to be acting in good faith to make sure that information isn't disclosed. So this is not like, oh, I know this about this person, let me post it on Facebook. You would be in violation of the law. By the way, you don't have to prove through any medical exam that you meet the categories to use these agreements. I forgot to say that earlier. The law says if you think that you fit into a person with a functional impairment, we believe. Yes, you can have multiple supported decision-making agreements. Makes sense. You and I don't necessarily go to the same person to talk about taxes or fast food chain restaurant preferences or where to buy a car. It makes sense that we want a wide network of people who can help this person out in whatever way they need. Yes, you can have different supporters for different decision types, and you can have more than one, even in the same supported decision-making agreement. Again, that idea that we're building a network of support that is diverse, that has multiple people in it. My friend George, a parent who worked on this bill, used to say before supported decision-making, there was either nothing or full guardianship. And neither one of those things was right for my son. This at least lets us spread out the work to support him across many different people. And for him, that was the most important thing, because what he was worried about is, how do I make sure there's a network of folks in my son's life that when I can't be there, either temporarily because I'm somewhere else or eventually permanently, that's not it. Like the whole support system hasn't left. So the person is always in control. Agreements are flexible. You can choose to end them at a specific date. You can adjust them anytime you need, add roles, subtract roles, add a decision area you want help with, remove a decision area you want help with. And, the person can decide they don't the agreement at all at any time, and so can the supporter. And that's important, because once you're appointed the guardian, you're always the guardian unless the court says otherwise. But that's not how people's lives usually work. Sometimes you have supporters who have an illness of their own, or have young children, or something happens to an older parent. There may be reasons in people's lives that temporarily or more permanently, maybe they move across the country, they might not be able to fulfill the same level of care, of support. That's okay. This is easy to adjust under a supported decision-making agreement. And yes, if you're a supporter and you're abusing the person, it's automatically revoked. There is that provision in law. Some more things that got included when we passed this law. The important thing is that, professionals are supposed to understand and recognize that if they receive a supported decision-making agreement, it is a legal representation of what that person wants. Just as if they receive a power of attorney, they understand that agreement is, what that agreement is. They don't, right? Like a lot of professionals don't know the difference between necessarily a power of attorney, a guardianship, or a supported decision-making agreement. That's a big piece of education that we try and do. But they shouldn't be telling you, oh, I don't know what this is, so I'm not going to accept it. No, you are required, like it is a legal document. And if they act in accordance with the agreement, they're not held liable if somebody doesn't like the decision later. All right, so how do you use a supported decision-making agreement? The law actually has elements of the form in it. We put the form right into the law, which is a little bit unusual. All you need to do to fill out and have a supported decision-making agreement, you need the name and the contact information of the supporter or supporters. This person needs to identify what kind of decisions do you want help with? What role do you want the supporter to play? If you want effective dates and any end date or not, it could be open-ended. And then to make it official, you need the signature of the person, or the mark, the supporter, and either 2 witnesses who have to be over 18 or a notary public. You do that, you got a supported decision-making agreement that's valid. There are several items that are included on the forms, kind of major categories of decisions that you can check yes or no, this is what I want help with. The only thing I emphasize here is this glorious bullet at the end that says other decisions. That is what makes these agreements so flexible. Lots of people, probably want help with these first 6 bullets. They're major categories that affect a lot of people with disabilities and other folks that have functional impairments. But this other piece is what makes it absolutely able to be tailored to any need the person has. The law says, well, if you don't check yes or no, presume you're not giving the support, or you don't want help with that, just so you know. So it's an affirmative, yes, I would like help. Our board actually put together a full toolkit that I'll post in the chat in a little bit about for families and people with disabilities. And I put this in here because a lot of times, again, that the cultural bias is that the person with a disability shouldn't be or can't make their own decisions. And this is one of our pages that really helps empower the person to remind the people they're interacting with that, no, I am actually in charge here. I sometimes need help, but that doesn't mean that I'm not able to make my own decisions. Talk to me, not the person with me, because the decision is about me. These bullets are really kind of responsive to the experiences that many people with disabilities have had. And they're good reminders for professionals too. I don't know how many people you've run into, and sometimes I might be guilty of this too, where that explain things in a way other people can't understand. We all need to be reminded sometimes to slow down and be understandable. For professionals, there is some work that you can do, and their teachers have all sorts of forms you fill out too. You want to make sure that your organizational system has a place in it for supporters. You want to make sure that your system has a place to keep on file supported decision-making agreements, powers of attorney, guardianships. You want to make sure that your policies acknowledge and reflect that supporters are folks that professionals might expect to interact with in various situations. And we put these things in here because a lot of professionals, these are basic communication tips that anybody really could use, including myself. But thinking about how we interact in some of our meetings and how fast people are intended to go, it's good to remember to kind of take a breath and go, okay, is how we're conducting the meeting actually not what the people in the meeting need to make a good decision? Give the person time to think. Make sure that you're asking questions and make sure that the person isn't, feeling pressured that they have to respond right away. Lots of people process information differently. Use plain language. Make sure you know what the role of the supporter is. All of these things just help give a better meeting, no matter what the meeting is, even if there's no person with a disability involved. But it's a good reminder of how we all need to think about other people hearing, interpreting, processing, and making decisions. Oops. One of the biggest aspects of this law is it allows a role for people who are not necessarily direct relations. And my friend Janet, who works with the aging community, said for her, this was the biggest thing about this law. She knew a lot of older women where the people who were closest to them and interacted with them on a daily basis and really knew them were their friends. Maybe their kids were in different states or living far away. Maybe they didn't get along with their children. Maybe they never had them. Maybe their husbands preceded them in death. Maybe there was no extended family around. This supported decision-making agreement allows people who are involved and engaged and know the person to have a role formally that's designated by the person and affirm that this is why they're there, right? So it's that whole idea of your social network is broader than just your family. And sometimes your family is not necessarily your best social network. We have great parents. That's not a slam against anybody. But, I think about I've known a lot of siblings who don't get along really well. I know a lot of people who are like, no, my sister could never be in charge of any decisions over me, right? So there are relationships that are close and work well. And there are also some that, yes, people are closely related, but they're not necessarily close. Supported decision-making can really be adjusted. So, for a lot of people with intellectual and developmental disabilities who are young, and we would expect to grow and learn over the course of a lifetime, maybe you start with something that is, more hands-on at the beginning, but you might, you being the person and the supporter, you might revisit that supported decision-making agreement multiple times, and it might change, and it might become really less intensive over time. Conversely, if somebody is in the beginning stages of Alzheimer's, well, you could have a supported decision-making agreement that evolves and becomes more intensive as the needs change. Person with Alzheimer's doesn't necessarily need a guardian immediately. They might need a guardian, 20 years from now, but such is the span of, a degenerative disease. So it allows folks to transition either up or down, and it allows a way to provide a little support for a long time. So where are people using supported decision-making agreements? Kind of every place that we talked about in the transition slide, right? So we have various types of meetings that some of you are probably already familiar with, appointments that are very typical, housing arrangements, choosing a provider. All of these things are places where people are using supported decision-making. They're also using supported decision-making to, two ways, right? To help the person be clearly understood, kind of the supporters acting as their translator to the professional. And also the other way, the professional is being translated by the supporter to the person. And that can be really helpful. I always use medical examples because nobody should go into a medical appointment alone is my philosophy. And it's not a thing against doctors. It's that they're professionals who have 15 minutes with a patient. They're explaining extraordinarily complicated information, usually using a lot of complex terms and maybe acronyms. And they understand that information really, really well. And they're talking to somebody who may not be feeling well, who may be on multiple medications, who maybe needs time to process. And it might be information that's hard to hear anyway, right? Like, as in like emotionally hard to hear. So it's always good to have somebody in the room who can help ask the questions to make sure what's being said is understood. To remind somebody that, you know, to explain things in a way that the person understands. And a doctor doesn't know necessarily that how to best explain to a person with a developmental disability what's going on. That doesn't mean the person with developmental disability isn't able to understand. They just need it transferred into terms they understand. So the supported decision-making agreement form is available online. You can print it out and you can fill it out and get it signed either by 2 witnesses or a notary, and you have yourself an agreement. It is designed to be able to be done for free and easily. Nobody has to go to an attorney. Nobody has to go to court. There aren't any fees. It's just there. That's also true for powers of attorney. There, you can just fill out the form. Although most people, a lot of people do approach an attorney about that because there's so many different ways you can make them. We have a toolkit, and I will post in the chat our kind of worksheet set for parents, which are available also in English and in Spanish and Hmong. So if you are working with students where English is not the primary or first language, we have translated a couple different ways. And of course, I always have to throw in the statute because, you know, I like to let you know that it really does exist if you want to read it. Okay, and I'm at 7:01. So if anybody has questions,
You did
I'm happy
good.
to take them.
You did good. That's really nice timing. So yeah, please unmute. If you have questions, you can also put them into the chat and I will relay them to Tammy. So whoever unmutes first gets first question. Go. I guess it was pretty clear, Tammy.
Well, it's a lot of information, and
It
I
is.
know that I went fast and it takes some time to absorb.
Oh, absolutely. And that's the thing, is that I know that a lot of it will be going to the resources, check them out, and then being able to ask further questions after that. So thank you, Linda and Emily at Adams Friendship. Good to see you guys. I'm sorry that, you know, they can't afford to give you a working microphone. That really kind of sucks. Sorry about that. But I'm glad that you were with us and hopefully you found this helpful. Good. So we will share Tammy's PowerPoint as well as putting together a resource sheet for everyone based on tonight's conversation as well as previous presentation that Tammy's given. I now have this wonderful resource sheet that I just basically copy and paste because she does such a good job. So any questions or final comments? Seeing none. Thank you, Tammy, so much. I learn something every time. Tonight I learned I'm not durable. So thank you for that. I appreciate the fact that you said that I'm not durable. I will remember that. But I really do appreciate the insight. I love all the work that the board has been doing on supported decision making. I know that there is now the training that you guys did in February is now recorded if somebody wants to watch that. And there's so many options now, so many resources that are available. Hopefully we'll continue to get more.
Two final plugs for you and all your friends. We did do a full half day training that was virtual in February, and it was this presentation as well as a presentation about how do you use these different tools together.
Ooh.
And then a presentation of a panel of self-advocates who are using supportive decision-making agreements in their lives. So we did that in February, and it was for continuing education credits. And we are planning to keep doing that because we got feedback that that was needed. So I think in the fall, it'll be free. It'll be open to anybody. It was recorded. We will do that again. The other thing that we have kind of keeping in your mind, we passed a law this session to require training for guardians to help them understand before they're appointed what actually is involved with a guardianship. And that includes education about alternatives to guardianship. The training isn't developed yet, but it is supposed to be, again, free and online. That the whole idea with the law was to make it easy and accessible to everybody. So that will be something that we can look forward to in the next couple of years as well. And that I hope would be a great resource for parents and as you are working with transition age folks.
Oh, absolutely. Because I mean, people are always asked, well, what does it mean to be a guardian? What's involved in that? So having sort of a training that helps them understand what their responsibilities are is going to be very helpful. So I look forward to that. I also did remember to pop in the feedback form into the chat. So if before you log off, if you could go there first, it'll take approximately 45 seconds. Okay, maybe a minute and 45, but we'll see. But thank you for that. I'll also send that out along with all the follow-up materials. So this is our last Transition Talks Tuesdays with Juneau and Adams County. We will be redoing this with probably some other school districts or counties in the fall. And we will be inviting anybody who wants to join us. But I do know that Ms. Julie is looking forward to doing some other stuff in Juneau and Adams, such as maybe a What's After High School training, a Did You Know Now You Know training.
And a what training?
Maybe we'll do a support decision making. Which trainings did you want? What's After High School? Did you know now you know?
Yeah, that one we've done before and we'd love to do it again because it's been a while. In fact, just before the quarantine, we were starting to line up another What's After High School event, and then we got the quarantine, and so we're definitely due.
All right, then we are coming to Juneau County in the fall with What's After High School.
Looking at possibly November.
That sounds great to me. Let's talk and let's find dates.
Absolutely. I'll see you
Fantastic.
on Thursday, Tim.
Oh, yes. Circles of life.
Yes.
All right. Well, thank you so much, everybody, for being here, and especially those that I think have actually made all 8 sessions. You guys are amazing. So thank you. And thank you, Tammy. Yeah, everybody have a great night.
Good night.